Hi everyone, and welcome to Lili Tsourdi, who is tonight with us to discuss a very hot topic, very big in the agenda these days. I'm sure you've all heard about the emergency with immigration in Europe. So we decided to call this the EU immigration crisis because it is so much true these days, actually. Not that migration is always a matter of crisis and emergency, but certainly it is these days. And we think it is a great privilege for us to have today Lili, who is an expert in the field. Lili comes from the Free University of Brussels. She also has an affiliation with the University of London and with the European University Institute, EUI, here in Florence, which some of you might know is an institute for advanced studies. They have PhD students and scholars working in the different fields, all dealing with European integration, the EU, and the most urgent problems in the EU. So certainly it's the right environment for Lili and for her research. Lili has a specific interest in immigration policy, in EU asylum law, and she has developed an expertise in the field because she has participated in several research projects, international projects. Also, she has acted as a consultant for international organizations, and also she had a direct experience in the field, which I found very interesting because she collaborated with a member of the European Parliament who informed some of the legal documents that were then used for the EU asylum package. So I think that there is here a good mix, of knowledge of, a scholar and a practitioner. So thank you very much for being here, and I think this will be very useful for all those who will attend the Brussels trip at the end of the month, but for sure it will be of great use to all those who are exposed to the news in Italy and in Europe these days. So the floor is yours. Thank you.
I'm very excited to be with you today. Thank you very much for your kind words, Nicolo, and for the invitation. And I'm very happy to see so many of you here to discuss about this topical but also very important issue. I would like to start by showing a small video that I think provides a bit context into the current immigration refugee crisis that the EU is facing.
In the summer of 2015, Europe experienced the highest influx of refugees since the Second World War. Why? The main reason is that Syria has become the world's top source of refugees. Syria is located in the Middle East, an ancient, fertile land settled for at least 10,000 years. Since the 1960s, it's been led by the Al-Assad family, who have ruled it as quasi-dictators until the Arab Spring happened in 2011, a revolutionary wave of protests and conflicts in the Arab world that toppled many authoritarian regimes. But the Assads refused to step down and started a brutal civil war. Different ethnicities and religious groups fought each other in changing coalitions. ISIS, a militaristic jihadist group, used the opportunity and entered the chaos with the goal to build a totalitarian Islamic caliphate. Very quickly, it became one of the most violent and successful extremist organizations on earth. All sides committed horrible war crimes using chemical weapons, mass executions, torture on a large scale, and repeated deadly attacks on civilians. The Syrian population was trapped between the regime, rebel groups, and the religious extremists. A third of the Syrian people have been displaced within Syria, while over 4 million have fled the country. The vast majority of them reside now in camps in the neighboring countries who are taking care of 95% of the refugees, while the Arab states of the Persian Gulf together have accepted 0 Syrian refugees, which has been called especially shameful by Amnesty International. The UN and the World Food Programme were not prepared for a refugee crisis on this scale. As a result, many refugee camps are crowded and undersupplied, subjecting people to cold, hunger, and disease. The Syrians lost hope that their situation will be getting better anytime soon, so many decided to seek asylum in Europe. Between 2007 and 2014, the European Union had invested about 2 billion euros into fences, high-tech security technology and border patrols, but not a lot in preparation for an influx of refugees. So it was badly prepared for the storm of asylum seekers. In the EU, a refugee has to stay in the state they arrived in first, which put enormous pressure on the border states that were already in trouble. Greece, in the midst of an economic crisis on the scale of the Great Depression, was not able to take care of so many people at once, leading to terrible scenes of desperate, hungry people on islands usually reserved for tourists. The world needed to come together and act as a united front, but instead it has become more divided. Many states downright refused to take in any refugees, leaving the border states alone in their struggle. In 2014, the UK lobbied to stop a huge search and rescue operation called Mare Nostrum that was designed to stop asylum seekers from drowning in the Mediterranean. The idea seems to have been that a higher death toll on the sea would mean fewer asylum seekers trying to make the journey. But of course, in reality, that's not what happened. The perception of the crisis around the world suddenly changed when photos circulated of a dead boy from Syria found lying face down on a beach in Turkey. Germany announced that it will, without exception, accept all Syrian refugees and is now preparing to take in 800,000 people in 2015. More than the entire EU took in 2014, only to impose temporary border controls a few days later and demand an EU-wide solution. All over the West, more and more people are beginning to take action, although support for asylum seekers has mostly come from citizens, not from politicians. But there are fears in the Western world.
I'd like to stop here, but the resource it's longer and it's in your PowerPoints and you can get back to it if you want to see the rest. But I thought it was interesting as it raised quite some of the points that we will see together as well tonight and some of the important points. So I had also, in case technology had let us down, I had put some statistics to provide the context in another way. So as you see, the Syrians alone, we are talking about a refugee group of more than 4 million people since 2011, when the armed conflict began. And they mainly find themselves in the neighboring countries to Syria. So the majority is hosted by Turkey, but also Lebanon and Jordan, and it is actually a minority of people who have sought refuge in Europe. But the arrivals by sea have risen in 2015 to almost 600,000. And of course, there have been a lot of deaths and persons missing, trying to make this journey to arrive to safety. So among these arrivals, and this is important because we will also speak about the crisis of words and whether the people that are coming are actually migrants or refugees. So it is important to note that among the arrivals, 83% come from the world's top 10 refugee-producing countries. This does not mean per se that they are refugees, but of course there are many possibilities that they are. It's quite likely that they are. And we have had a rise in applications in the EU 28. I have made this own calculation from Eurostat. It's not to the person, but it gives you about the class of what numbers we are speaking. But we must not forget that we are talking about the entire EU, the EU 28. At the same time, for example, Lebanon alone hosts around 1.2 million Syrian refugees. So these are some pictures. I don't want to shock you and sensitize you, but this is the realities that people are fleeing, and these images come from Syria. But such situations are faced also. Of course, this is the load of asylum seekers where now there is most of the attention, but this is not the only area in the world where there is where there are problems, where there is ongoing armed conflict to a large scale. This speaks, I think it's quite telling about the Common European Asylum System, that it is a fantastic house, but which has no doors to come in, just very small windows that most of the time you even have to break in to come in. So the majority of asylum seekers arrive in the EU irregularly. So there are very limited ways by which an asylum seeker can be granted access already from the third country to come legally into the EU as a protection seeker. So most of the people, of course, the sea route is the one that has been most mediatized, but also land routes. Most of the people arrive here irregularly, either with fake visas or trying completely to pass undetected. And here this speaks to the political crisis, as we will come back to it, and how different actually member states have found, instead of, this was also shown in the video, instead of having greater unity, actually, we have had a confrontation and political tension coming from this issue. So we talk about an immigration crisis, but actually the crisis has many faces. So first of all, it is moral, because providing protection to those fleeing persecution, to those fleeing armed conflict, to those fleeing human rights violations is not just a legal obligation, although I am a lawyer, and there is a great importance in the fact that it is a legal obligation, but it is also a moral obligation, and it raises profound ethical considerations. The crisis is also religious. We hear in the debate in many member states that actually political decisions are made on the basis of the religion of the asylum seekers, and a particular group is wanted or not, and fears about what this will mean about the cultural identity and the religious identity of several member states. It is also political. We will see later how actually the responsibility allocation regime has been defectively actually developed. But we see that now, when the system has come to a great amount of strain, the political tensions surface. It is also institutional, in the sense that for the first time there had to be within the council a qualified majority voting for the solution that was found on relocation of asylum seekers, meaning that asylum seekers that had arrived in one member state been transferred into another. And this was a very politically sensitive decision. And usually these decisions in the EU, unanimity is sought, but for the first time this measure was taken against the will of 4 particular member states. So we see clear political and institutional tensions. It is operational. What are the means that the EU has at its disposal to help the individual member states? And can these means be quickly and effectively be brought to the ground to help member states? And it's also, as I mentioned, a crisis about words and about numbers. So the people that are arriving, are they migrants who have no irregular migrants who don't actually have a right to be here? Or are they refugees, or as we hear often, genuine refugees, which is a pleonasm? And also a crisis about numbers. So how many refugees can the EU handle? We are hearing different member states talking about an overburdening of the system, or the fact that Europe cannot handle more persons arriving. So we see that this crisis has laid bare also tensions that exist perhaps in other areas, and is testing the entire EU construction. So, but I wanted to take a step back and review a bit with you the human rights issues that are at stake, because we are using different words, asylum and refugees and non-refoulement. But I'd like to see a bit with you what this means, And I'd like, in the true American way, that you feel absolutely at ease to stop me and to ask questions and to ask clarifications and to interact. So starting with the right to asylum. So although we speak about asylum a lot, there is surprisingly no internationally agreed legal definition. So the right to asylum, and for those of you who maybe have followed the class on human rights, it is a part of the Universal Declaration of Human Rights, but this is a soft law instrument, so it is not per se legally binding, although of course it has inspired other legal instruments that are binding, that create concrete obligations for the different states. So here I have put the opinion of an eminent refugee law professor, one of the forefathers. So it is the right to live in the territory of the state that is granting it, and not permanently, but so long as it may be necessary in order to escape persecution. So we have in fact a right to stay. This is inherent in the right to asylum. So what about refugees? So we come to the next question. The right to asylum, who should have this right to asylum? So one category, one link that is coming to mind is refugees. And who are refugees at the international level? We have here a legally binding instrument, the 1951 Refugee Convention, that has a definition about who belongs in this category of people. I know it's a legal definition, it's maybe linked in your minds with boredom, but I have tried to bring out the main elements in red. So we are talking about a class of people who had in their country of origin or habitual residence a well-founded fear of being persecuted, and this on the basis of one of the 5 reasons that you see. And they find themselves already outside the country of their nationality, because also there can be people of concern who have been displaced within their country of nationality, and this is the case in Syria, but these people are not refugees, they are internally displaced persons. And so due to this fear, these people are unwilling to avail the protection of their country. So their country can no longer protect them. They cannot it cannot guarantee their basic human rights, or it is outright persecuting them. The state is the persecutor. So this is one class of people, but asylum is broader than the class of refugees. And this is also depicted in the EU asylum policy. So, I had another slide about the rule of non-refoulement, which is also in binding legal terms in the Refugee Convention. So, in very simple words, what does non-refoulement mean? It means that states may not send back people who fear persecution in that country to be persecuted. And not only in that country, but also in another country which might send them afterwards to the country where they fear persecution. So this is the mysterious principle of non-refoulement. And this exists also in human rights law. So this is why I say that the class of protected persons is actually broader than refugees. So we have in different instruments, legally binding instruments, either at global, either at European level, the prohibition of torture, inhuman or degrading treatment. We saw before in the Refugee Convention the notion of persecution. Here we have torture, inhuman or degrading treatment. And this prohibition is so important. It is one of the basic values in a democratic society. And this is why courts and governments have found it to be absolute. And what does this absolute character mean? Of course, that torture by the state itself, of course, and inhuman and degrading treatment is prohibited. But also, what I say here, that there is a non-refoulement component. And what do I mean in simple words? It's that also states cannot send back to a third country or to the country of origin a person if they know that there he has reasonable grounds to fear that he would be subjected to torture, inhuman or degrading treatment. But the difference with the Refugee Convention is that although in the Refugee Conventions the ones found to be refugees have also a clear set of rights that are attributed to them, and these are far-reaching social rights, education, right to work, there is an absence of such a clear framework of rights in human rights law. So here the main point is non-return, but actually the situation of persons afterwards is not regulated in such detail. So all this to just tell you that when the EU started creating the European asylum policy, it did not start from a completely clean slate. It had its moral obligations, it had of course all this background, but it clearly had also pre-existing legal obligations. So I raised some of them. The Refugee Convention. In Europe we have our regional instrument, which is what for the global level is the ICCPR, the Covenant. We have here the European Convention on Human Rights. And we also have other instruments that create obligations to ensure social rights. And very specifically in the EU, we also have our own Charter of Fundamental Rights. So in fact, all the behavior of the institutions and of the member states should also abide by these rules. And that, when I say behavior, I mean also how they legislate and also how they act. So this is the backdrop on which the European asylum policy was developed. So what happened in Europe? As I said, it was not that we had a clean slate, so we had disparate national systems. So every member state had its own system by which it was trying to fulfill its obligations and to respond to refugees. And in 1999, the decision was taken that actually there should be a common project, what we call in the jargon of EU law, harmonization of legislation, which means to try to create common standards that would be then transposed, meaning applied in all member states. And because this was a rather ambitious project, the EU went about it in two stages. In the first stage, we talked about minimum standards, so legislation that at least ensured a minimum. And in a second phase, though, we had a more ambitious role, so a common area of protection, comparable standards of reception in all member states, a common procedure, uniform status, so quite ambitious for actually an organization which is not a federal state, but which is created by different individual member states who collaborate in a framework, but who have also disparate social assistance systems and social welfare systems, or different financial situations. So there were within the system, we see already inherently its limitations, but this was the ambition. And at the first level, as usually in the EU, we focused on the law. So legislating, harmonizing, we had two phases of harmonization. The question that I have put is rather rhetorical. You are all here because you have all seen the news. Obviously, legal harmonization is not enough to create a common system. And this is the reality. This is when member states woke up and smelled the coffee and saw that it was very nice. It was a necessary first step, but it would not be enough to actually create a common system. And this picture is from the quarters where asylum seekers were staying in Patras, in Greece, in an abandoned warehouse. So the provision or not of reception conditions, the level of asylum procedures, even after this intense phase of legal harmonization, so of trying to bring our legal framework together, was quite disparate on the ground. So the EU was not completely ignorant of this until the latest crisis that has been mediatized, but already from the first phase of harmonization, it became apparent that something more could be done, but it actually happened with very, very slow steps. So here I try to take an overview of our system, of the Common European Asylum System, in a kind of SWOT analysis, so to take just the strengths and the weaknesses. So here in this slide we have the strengths of this regional protection system. So first of all, as I told you, we have detailed norms on how procedures should run, on what rights asylum seekers have, and these go beyond what exists in the Refugee Convention. So we definitely have a step forward there. Then we have a concrete mechanism to allocate responsibility. And I will come back to this, but the system has the architecture that if we are a common space of protection, we need to find among us which will be the member state that will be responsible to examine each application. So there is a kind of mechanism to allocate that. This is also unique in a regional cooperation. Then we have a court, the Court of Justice, that is tasked with interpreting the common norms. So individual asylum seekers do not have the right to petition the court, to present themselves before the court, but there is a mechanism, and maybe those of you who have followed a bit EU law have heard about it. National courts can ask a question to the Court of Justice about the interpretation of the norm that can give them an authoritative answer. And then this is actually the law for all member states. So this is important because this is an area where there is no international refugee court, for example. So this is a gap that is being filled. We also have institutionalization of practical cooperation efforts. What a pompous phrase. So what does this mean? There were actually efforts of member states to collaborate with each other, to help each other, to learn, to exchange practices, to become better. And we have created in the EU a dedicated agency that is coordinating this. And we will come back a bit to its actions. And what about the EU and the rest of the world? Well, as I told you, there are not so many ways to legally access the system, but there are some actions on the external level which are mainly focused on providing financing to build capacity in third states. So the majority of actions has focused on that. So let's go to our weaknesses now, to the other side of the coin, and dysfunctions. So first of all, I mentioned to you, there is a responsibility allocation mechanism. I never said that this is, though, a mechanism that distributes responsibility fairly. Quite the opposite. And this is one of the main weaknesses of the system, and this is where I will return afterwards to explain a bit in more detail what is happening. Also, when we say, is responsibility shared fairly or not, already there is a precondition, a question before that. So what is a fair share for each member state? And how are we going to objectify this? What kind of indicators are we going to use? This is a discussion that still today has not taken place in the EU. So one of the other weaknesses is that, of course, as we were talking about systems and member states that had wide discrepancies in their social assistance system, and later on had a different level of investment of how to prepare, of how much money to give to their services, to build reception centers, to run asylum processes. We have widely diverging recognition rates. So a refugee of the same nationality in one member state could have 60% chances of being recognized, and in another they might have 1 or 2% chances of being recognized. So we are talking even about such extreme discrepancies. And there are no legal entry channels. There is resettlement. Those of you who are from the US probably have heard about the refugee resettlement program, so a way for refugees to come legally from third countries to enter as refugees. For example, the US, Canada, Australia, also Europe, but this is a very, very small number of people that come through these means. Till very recently, it was for the whole EU28 around 10,000. And now, since the Syrian crisis, it is a bit more, and mainly due to specific member states. For example, Germany had a program whereby it allowed 20,000 Syrian refugees to enter legally, so as protection seekers. But you see the numbers of displaced people, and you already see that this is quite little in comparison. So not only, though, do we not have legal entry channels, but we have, as you saw also in the video, created an intricate system of external border controls, which is, of course, justified, the prerogative of the state to control and protect its borders, but they had an effect, a clear effect of blocking asylum seekers or genuine refugees, if you will, to enter the EU territory. So what about the responsibility allocation? Because this is where the main problems behind the crisis that we face today can be traced. So this is again an EU jargon. This first legal instrument was agreed in Dublin. So you might hear often in the news the Dublin system and the Dublin regulation, and in case you have followed. So this is where the jargon comes from. So we also call it the Dublin system. It's the system that allocates responsibility for the examination of asylum claims. So this is built around the one chance only principle. And what do I mean by this? I mean that although we have 28 member states, there should be only one that would examine the claim. So they wanted to avoid the scenario of an asylum seeker going to France, being rejected, going to the UK, being rejected, going to Germany, and then this kind of orbit situation of forum shopping in all member states. So they wanted one member state to be responsible, which is a rational starting point, I would say. However, when then they tried to see on which basis actually they would choose which among the 28 member states will this member state, the responsible member state, be, they actually did not find the optimal solution. They found a hierarchy of criteria, which could be understood a bit as blame criteria. So which is the member state that is responsible for this asylum seeker, in a way, being here? Apart from very few, which are some criteria about family consideration. So if a member of your family, but family understood very restrictively, so with a very strict legal definition, so don't think all your cousins and aunts, so members, almost members of the nuclear family. So if they are recognized refugees or legally staying or asylum seeker in another member state, you can be reunited with them. If you have come, for example, with a visa, then the member state that gave you the visa will be responsible. But this, in the end, actually account for quite a small percentage of people, and the main criterion is the geographic criterion, the one I have put there, the one of entry or stay. So which is the member state through which the asylum seeker crossed irregularly by sea or by land to come to the Union. So already, as I told you before, I noted that we don't have legal ways or very few legal means for protection seekers to come to the EU. So they come irregularly, and what would be more natural in an irregular entry than that your first point would be a border point, either by sea, either by land. So we see that merely by their geography, under this responsibility allocation system, some member states are disadvantaged, the one at the external borders. And so this whole architecture creates a disincentive for implementation. So the member states, what I mean in simple words, the member states who are at the external borders say, if I run my system effectively and I have this responsibility allocation system, for example, if I register all asylum seekers who cross, I will end up with having, I don't know, the 80% of asylum seekers to be examined. Creates a disincentive for them to implement the legislation, and some of them have resorted to more violent means, for example, using detention as deterrent, saying, don't come here, there are horrible reception conditions, you will face horrible detention conditions. So a kind of market of dissuasion. And it creates also disincentives for the protection seekers. When they know that they will not have a possibility to be heard, to say, but I would like to go to this particular member states because I have links, because I have members of my extended family, they also try to cheat the system because they know that there is no space for them to be heard on where they wish to go. And all this has created a big, vicious circle of mutual mistrust, because we have the issue, what I call here the chicken and egg question in the solidarity and responsibility. So some member states say, this is an unequal distribution system, we need more help. But then at the same time, because of how this was, they had not invested also enough in their asylum systems, or they did not have, let's say, reception conditions according to the standards. And then the other member states tell them, but you are in this situation because you didn't invest enough. So this is why I say, first, they say be responsible, apply all the legislation, and then you will get help. But this does not work because the member states know that it can find itself in a situation of having what it perceives an excessive burden of responsibility. So here we are, locked in circles, while at the same time the treaties, the legal instruments contain the principle of solidarity and fair sharing of responsibility. This is just in this slide, I have a bit of a context because this principle means different things in different contexts, but it means something very precise in the migration asylum context. So there is an obligation for all these policies, including asylum, to be governed by the principle of solidarity and fair sharing of responsibility. So not only will responsibility be allocated, but it has to be allocated fairly. And this, as I told you, is also at the level of legislative production, but also implementation. And here, this is what I said, often this part of fair sharing of responsibility is gone in many political declarations and documents, and they speak about solidarity and responsibility while forgetting to talk about the fair sharing element. So this is not limited to financial assistance. It could also imply sharing of people, as we have now the so-called relocation efforts and schemes. It is a solidarity between EU member states. So as it is actually developed in the treaties, it does not apply in the EU, for example, showing solidarity per se with Lebanon and Jordan. So there is no obligation to share responsibility equally with third states. And it is a very strong language if we really hear about it. So whenever necessary, there are supposed, so I say this could be whenever member states cannot fulfill their obligations by their own means, there should be an intervention through this principle, either by the EU institutions, either through other member states. So what has happened? What has happened on the ground? Has this been realized? Did we have this intervention? There was actually never the institutions, the EU institutions, never pronounced themselves very clearly on what the implications of this principle were. And they have more said, we are going to, usually there are different words in the EU jargon, we are going to have a toolbox approach. So solidarity is made up of different tools, our financing, our practical assistance, and we are going to do something that will be in this toolbox. So I don't want to go into all the details. This will be, you will have the PowerPoint later and you can look at it. One of the tools is funding. There is EU funding that is from the central level, it goes back to the member states from the EU budget in order to do actions on migration and asylum. But what is very important to know about this funding is that it was conceived to have a top-up effect. So but what I mean by that is that it's not supposed to cover 100% the expenses of member states in this area. It was more naively thought that member states could fund them from their national budget, and then there would be the EU funding like cherry on top of the cake to do an extra training, to do something additional. So it only covers about 10% of expenses. So we see its limitations. I will not go into all the details. Then we have practical cooperation. What I told you before, that we have an agency. But what has the agency done very concretely so far in practice? We had something until this moment that was more akin to expert consulting. And I did some research actually in Greece to see how the teams of experts that had been mobilized, what they were doing on the ground. So you had training activities, you had also consultancy at the ministry level, but what you didn't have, and this was due also to the legal mandate, the regulation of the agency, so what it is possible for it to do, but also according to its financial means, it is quite restrained, so it cannot be operational. So far, we must not think that we had deployment of hundreds of professionals registering refugees and providing shelter and going through applications. In fact, the agency is quite restrained in that it must not make individual decisions. That is not its role. And also that any deployment is dependent on the member states. So the member states at the first level say, I have, I don't know, X number of experts to go to an expert pool that could be deployed in terms of emergency, but then they have to actually agree to make them available and for the time that they make them available. So still there are many limitations. And I make a comparison with Frontex, with another agency that is coordinating actions on external border. There, we have more an operational presence. So there we have more money, we have more people deployed, and they are more also doing on the ground one-on-one interaction with migrants and registration. So what about distribution of people? Because we talked about money, we talked about legislation, we talked about exchange of practices. So is there a way, a means within the system to distribute people after we had this unequal distributed effect of what I call the Dublin system? So there was an instrument, the Temporary Protection Directive, that was actually made in the aftermath of the Kosovo crisis in the 1999, 2000, 2001, where they said that people arriving massively and fleeing armed conflict and grave human rights violations could have a kind of temporary status, and also that there was to be a mechanism of voluntary redistribution. Because of the way this instrument was constructed and of its mechanism of activation, it has never, even if we have the Syrian crisis, as you see, it has not been activated to date. So this is a theoretical discussion. We did have a very small-scale relocation project before we had these debates, the relocation debates, the most recent ones, but it concerned, as you see, very few individuals. It was a very concrete case of Malta, and it concerned around 200 people, 300 people, so extremely small scale and on a voluntary basis. We have in our legal framework this possibility. So what happened and we also don't have even when you are recognized. So as an asylum seeker, these are the rules of how you are distributed. One might think, okay, but maybe you can move freely after you have been recognized. Well, the same rules apply as for other long-term residents who are legally present in the EU territory, which means that they can circulate after 5 years. And certain strict conditions apply, so you need to be making a certain amount of money. Maybe there are integration conditions, like speaking the language of the other country. So in practice, this is a very limited possibility. So what happened was that we had what I call an ad hoc distributive effect, because many national systems were actually very defective, and I spoke to you about the principle of non-refoulement. We had courts saying that, for example, you cannot return this person to Greece or to Hungary or to Italy because they risk facing inhuman and degrading treatment there. So we had in this sense a distributive effect, that people that should be returned to the member state responsible, that was the one at the borders, through the courts, individual, case by case, they were not returned. So the Commission tried to have a more ambitious plan in 2008 when they were rethinking of what to do with the Dublin regulation to stop transfers, but this was vehemently resisted in the negotiation by the member states. So what distribution of people? We have the geographic location, which, as I told you, obviously impacts on responsibility in the way that we have shared it so far. We have a lack of a mechanism to do this fairly. There is no other sharing of persons arrangement, or what sharing of persons we had was extremely limited. And we had member states resisting any change. So we had a dysfunctional system, but persistence to keep it. So quite a recipe for disaster, which led into the tensions that most of you have followed on TV and through media, with refugees arriving, with the border member states being overcapacitated and not being able to live up to their responsibilities, to an extent unable, to an extent unwilling, with the refugees having massive secondary movements from one member state to the other, and with, in fact, a great political tension on what we do. So the Commission finally said, we need to do something serious about this. We need to talk about Dublin. We need to rethink our distribution of persons. And in light of this extreme emergency, we need to share people, an amount of people who had arrived in Italy and Greece to other member states. And after a lot of political debate, it was agreed that this would happen for the amount at the beginning of 14,000 people, but arrivals were so speedy that before even the ink was dry, in this measure, the Commission came back and said we need 120,000 extra people to be moved between the member states. And what was the main problem? It was whether this reallocation would be done on the basis of voluntary or mandatory quotas. What do I mean? Would each member state say, I want to take 10 people, I want to take 300? The Commission thought for the first time no, that we will take some objective indicators like GDP, population, unemployment, percentages of unemployment, and that on this basis we will make a distribution key. So among these people, each member state, there was the first, let's say, effort to make a kind of objectivized assessment. So between these numbers of people, how many should go to each member state? For the 40,000, member states resisted. So they said, let's do it voluntarily, and they ended up with a lot of political pressure, just with 32,000. So when the Commission came back with the 140,000, it said, okay, this doesn't work. Already we tried for a smaller number and we couldn't even make it. So this time, let's go for mandatory quotas. So they will be distributed on the basis of this predefined key. And this is where 4 member states actually refused to do that, but it passed with a qualified majority, so with most of the member states agreeing. And these member states still politically say that we will resist, and we are not going to participate, and we are not going to relocate. So all this has brought up the tension of, okay, we have a common system, but who is responsible and to what extent, and how do we share this responsibility, and how do we agree? And we have a lot of mistrust. So member states saying, you're not doing enough, I am overloaded, you didn't try enough, that's why you don't do enough. So it's a very bitter debate. People are talking even about the complete breakdown of the system, but maybe I am by nature an optimist. I hope that through the crisis we will build something better. What else? There are discussions now of the agencies becoming more operational, so really of a greater number of people really being deployed on the ground and registering people and taking more active part. And this shows also the tendencies towards perhaps more centralization. So do we have maybe an agreement for a more centralization? Are we going towards a European border guards agency, for example, or are we going towards a common authority to examine applications? There is a promise by the Commission that it will review the Dublin system and that maybe it will come up with a kind of permanent relocation mechanism or redistribution mechanism to be seen. And there is a studying, it is being studied whether one could transfer the protection status, what I was mentioning to you before, that you are recognized in a member state, but you are free to go and settle in another, for example, in the same way that EU citizens can move around. That's it from me. Now I would like you to voice your opinion. You are here, you are many, you are obviously interested in this subject. So I'd like to hear your views. I have set up a number of questions, but feel free to ask me something that troubles you or say your opinion. Share your opinion.
To what extent is the crisis now a failure to anticipate such large numbers of non-European refugees coming from outside, flooding in this way? Were the systems set up, anticipated for sort of, people who flew and were coming in at a much smaller rate? Is that simply the reason why the mechanisms were the older mechanisms are so inadequate to the problem, or is it more about the combination of newer member states who are less able to take on refugees, or what do you see as the origin?
Mm-hmm. So there was certainly the element of also unwillingness of member states to prepare adequately, because it was considered that if you had a good preparation, you see, when there is no objective assessment of what is your fair share, the more you have, the more you could be asked, for example, to take, or you couldn't say I'm overloaded, you would still have capacity. So there was an incentive within the system not to prepare well. Also, to an extent, it was a bigger growth in asylum applications than what member states were used to up to that point, because of the intensity also of the conflict in Syria and the intensity of displacement. But also, some member states, for example, are not in the, to an extent unwilling, that's the problem, how to untangle the two, to an extent unwilling to prepare, but also unable. For example, Greece, facing a major economic crisis, it says, I have to cut my social welfare systems for my nationals. I don't have own money at this point to invest into assistance for massive numbers of asylum seekers and to provide them with roof, with food. Also, there is the issue of investing in different areas. The same member states are at the external border, so they have also a great investment of actually safeguarding the external border. So border controls, this is the one side, and Italy very righteously took in 2004 the decision to proactively do search and rescue, even in Libyan waters, through the Mare Nostrum operation. So this was costing a lot of money per month. And then all this number of people that they saved, which was in 2014, I believe was around 120,000 people. Well, because they were the ones who saved them at sea, they were the member state of first entry. So they said, so we are supposed first to give all this investment to save the people alone, and then we are supposed to process alone all the applications because we are the member state of first entry. So
in the event that Great Britain just chooses to remove itself from the EU, what impact will that have on the entire crisis and trying to fix the Dublin system?
Well, I didn't go into all the details, but this is an area, I will say first a big word and then I will explain, of differentiated integration. So what does this mean? That some member states, UK, Ireland, and Denmark has a general opt-out, and the UK and Ireland have the possibility, each time there is a measure on asylum, to participate or not. So already, they don't have to completely pull out of the union. They had already, when these measures were negotiated at the beginning, they had a special regime cut out for them. So already the UK, for example, it said, this relocation mechanism, I'm not going to participate. I'm going to do some resettlement for persons coming outside the EU, but I'm not going to take some of the people who are already here. So when I talk about mandatory quotas, we have to nuance, because this is the complex nature of the EU. Already the UK and Ireland have the possibility to say, I want to be in, I don't want to be in, as also with the asylum instruments. And here they have both said, I don't want to be in. So of course it would impact, as it will impact every area, but just to say that already they have afforded themselves a better position than the rest. And I believe that if they choose politically to opt out completely the permanent, for example, responsibility allocation mechanism, they could, unless they had intense political pressure, but for now they could. So in a way, they are already in and out of the Common European Asylum System.
So earlier in the talk, you brought up how religion takes a play into all this, and so certain member states have brought up the idea of discriminating on the basis of the religion, like they'll only accept Christian refugees. How does the EU consider all this or take into play this equation?
Well, the EU institutions officially find this, of course, unacceptable and against the principle of non-discrimination, and this is why actually in the instruments, I didn't go into all the details, but there were these two decisions now on performing relocation, and there is a possibility for a member state to say that there are reasons that it will not participate in the relocation, but it has been explicitly put in the law that these reasons have to be in accordance with its human rights obligations. So that, for example, not wanting asylum seekers of a particular religion would not be in compliance with their human rights obligations, one of which is the principle of non-discrimination. So they wanted to exactly target this, and they said specifically the reason why you could not participate could be, for example, that the flows have changed and that you are overburdened, but that it cannot be a matter of willingness in the sense of the nature of the asylum seekers or the color of their skin or their religion. So in this sense, the institutions are clear, and also in political declarations vis-à-vis these countries that have had this rhetoric. But of course, at national level, dynamics are different.
Yes, I was wondering what measures are in place to ensure enforcement of the mandatory quotas, and also if a member state decides to say that they're going to not participate in the mandatory quota program because of an issue of extreme national interest or security, what would the process be of challenging that if need be?
Mm-hmm. So first of all, this is very, very new. So the decisions passed in actually September. So now we just had the first flights from Lampedusa to Sweden a few days ago. So it's still very early days to say. Some member states politically at least have declared that they will resist and that they are not going to take part, but we don't know yet what they will do. So this is what they announce, but we will see in practice. So in terms of enforcement for the mandatory quotas, so far there was only this process that I mentioned to you. At the beginning, the Commission wanted to have a kind of financial compensation. So first of all, the reasons that you would raise for not participating would need to be human rights compliant. So you could not say, oh, I don't like the color of the people who are coming or their religion. But even then, instead, you would have to give an amount of money, which was quite a lot. It's 0.02 of the gross domestic product, I think, which is quite a lot. But the member states didn't go for that. And so instead, they said that the only thing that can be done is not that you cannot participate at all, but if you have valid reasons, you might delay for a while up to 30% of the relocation load for the future. But how it will be enforced, I mean, there are the rules, but what pressures, political, diplomatic, or whether they will go to other tools, we will have to see in practice, because this has just started the process. But still to say that considering the number of arrivals that we have, these numbers are still very few. So it's more of political significance. In the end, if you see how many numbers member states should take, most of them is 500 and 1,000. And so we are not talking about great numbers, but it's more the political, let's say, stance that they are keeping, and also they are thinking for the future, because now it is a finite number of persons, the 40,000 and the 120,000. But of course, if we start sharing persons in general, this could be an unlimited, for example, number of people. So that's why they're resisting the principle. But we will see.
So what happens when, in the long run, immigrants keep coming in, and they keep coming in, and the ISIS keeps operating, and they keep terrorizing people? Is the EU doing something to actually plug the problem from the source? Is there anything they're doing to get involved in Syria or with ISIS?
So this approach has been a lot in the debate. That's why I have talked about the issue of solidarity and responsibility allocation, but at the same time there have been other very hotly debated initiatives, which is dismantling smuggling networks as they operate also in Libya. Or there is also the approach of trying to broker peace, for example, so trying to tackle the root causes. But all of these, of course, approaches are in the long term. So, of course, you cannot say that in 1 month or 2 months I will have brokered peace. But yes, it is much more in the thinking now that this must be a concerted approach. Where also external relations and diplomacy and acting at the international level globally to find solution is very important. In the more practical level, there are discussions about how to dismantle smuggling networks. But of course, as we see, things are interlinked, because while you don't have legal ways of access, of course, smuggling is a crime, and the smugglers should be found and prosecuted, but at the same time, you are stopping the only legal means the only irregular means, but the only means that protection seekers had to come to the EU territory. So it's a difficult balance, while at the same time you don't open legal means for people to come.
Thank you. Good evening. Before we talk about data collection and regulation, but actually I know that here in Italy is not for refugees is not they are not obligated to give their information. So it's a problem for a country to make possible the integration. So I wanted to know, how is this possible? And why there aren't rules that make that make this possible?
Are you referring to the registration of fingerprints of asylum seekers?
Yes.
Yes, so I didn't go into all the technical details. This Dublin system, the responsibility allocation system, is also supported by a database. In order to find, actually, to trace where the people passed. There is supposed to be a registration of the fingerprints of asylum seekers or of irregular migrants, so that then when they go to another member state, they come back. As I told you about the disincentives to apply the system, of course, border member states that were flooded in a way maybe turned the blind eye and didn't fully proceed to fingerprinting of all asylum seekers in their territory. At the same time, the individuals themselves wanted to avoid this because they had a concrete plan of where they wanted to go. And so they wanted to continue on with their journey. Now with the hotspots, which is the other initiative, this is coming a lot to into the forefront because it is considered as a kind of quid pro quo, a kind of exchange. They're saying you will have the relocation scheme from your countries, Italy and Greece, but make sure to fingerprint everyone And you should know that you can only benefit from this if you fingerprint and examine the rest. So if you read these decisions, this kind of mistrust is very clearly portrayed. So there are clear instructions for member states on what they should do to also fingerprint asylum seekers, and also sort of sanctions for the member states who benefit from the system, that if they don't apply it, the relocation stops. And now there are discussions. Could you use force, for example, to fingerprint someone that doesn't want to be fingerprinted? And this we will see now with the operation of the hotspots that they have just started in September. So the fear is that there will be more and more, the hotspots will actually operate in a way as kind of spaces of deprivation of liberty, where there could also be an enforced, for example, fingerprinting. And then we have all the issues of inhuman degrading treatment. So what is justifiable force for this, and where are the limits for these purposes? So it is an area to look out for in the next months.
Okay, I think that we can conclude our dialogue. So I thank you, Professor Tsourdi, for this interesting dialogue.
Thank you. I'm not a professor yet, but thank you.